Welcome to this Dehns webinar on the topic of trademarks. My name is Alexandra and I'm an associate and trademark attorney in the Dehns Trademark Group in Brighton.
And hi, I'm Adam. I'm also an associate and chartered trademark attorney at Dehns in the London office.
This webinar is designed to be an initial overview of trademark protection and the key issues to be taken into consideration when thinking about registering a trademark. We're therefore going to be covering a number of areas at an introductory level, but please get in touch with us if you require more detailed advice or assistance on a particular issue. You'll find our contact details at the end of the presentation. So before we get started, for those of you who haven't come across Dehns before, we are a boutique intellectual property firm founded over 100 years ago. We have a number of offices in the UK, as well as in Munich and Oslo, and we offer the full spectrum of IP services. So that's from prosecution and opposition through to litigation and transactions. I'll now pass over to Adam to outline the topics in this session.
Thanks, Alex. So we'll begin by outlining what a trademark is and why trademark protection is important for all businesses, from startups and sole traders through small and medium-sized enterprises to larger organizations and multinational corporations. We'll then discuss a number of relevant considerations when it comes to trademark protection, including when you should look to obtain protection, what precisely you should be seeking to protect, where in the world protection is required. Finally, we'll explain how trademark protection is obtained in the UK and the types of issues and costs which might arise during the process.
So starting at the very beginning with what is a trademark? A trademark is any sign that is used to distinguish your product or service from those of other businesses. So for example, in a supermarket, you will see a whole cabinet of bottled water. The product is fundamentally the same, but customers can differentiate between them and make their selection based on things like the brand name, the logo, and the overall get-up. So in this example, that includes things like bottle shape. Another way of thinking about trademarks is that they are relational, by which I mean they are the main link between a business and its customers. And this link works in both directions. So on the one hand, trademarks are a form of marketing through which you can communicate your business and its values to potential customers. And then on the other hand, there are primary means by which customers can identify and remember a business, which in turn facilitates repeat custom. So trademarks are therefore central to every business's overall brand, and they help to protect the investment made in building a company's image, and so should always be taken into account during the brand creation and marketing process. So whilst trademarks are fundamentally a legal concept, this doesn't mean that there's no room for creativity, and there's actually quite a lot of flexibility in terms of the aspects of your branding that could be protected, because trademarks can take many forms. So most commonly, trademarks will consist of a word such as a trading name or the name of a specific product or service, or a logo, or a combination of the two. So to take a well-known example, Cadbury is a word mark which corresponds to a trading name. Dairy milk is a word mark which corresponds to a specific product. The Cadbury logo is a combination of a word and a logo, and then the milk logo consists of a figurative design alone. So these types of trademarks that you see on the slide, they're important for any business, and typically they form the starting point of most businesses' trademark portfolios. Having said that, UK and EU trademark law does allow for the possibility that a trademark might take a less conventional form. And this can range from slogans and the shape of a product to things like a sound or a particular colour combination. The difficulty with these types of trademarks is that, unlike names and logos, which customers are used to relying on to identify a particular party's goods, so going back to the water bottle example at the beginning, these other types of signs can be trickier to register as trademarks because consumers are less likely to associate them with one brand in particular. So turning back to Cadbury, over the years, Cadbury has sought to protect the shade of purple used on its packaging as a trademark, and other chocolate manufacturers have tried to protect the shape of their products, a notable example being the shape of Nestlé's Kit Kat. These applications have been the subject of numerous legal cases across multiple jurisdictions on the basis that these signs, so a single colour or the shape of a chocolate bar, are rarely deemed to be unique to one business alone. These cases show us that registering unconventional trademarks is not impossible, but is rarely straightforward and can be expensive. Despite those challenges, if you are successful in registering a more unusual trademark, its potential value can be really significant because they're extremely memorable, and in some cases they can become an iconic symbol of a brand. So we can look to the McDonald's I'm Loving It jingle and MGM's Lion Roar as good examples of this, both of which are protected as sound marks.
Now, why is it important to protect your trademarks? As touched on by Alex, your trademarks are what customers use to identify and recognise you. Trademarks are therefore crucial to developing public familiarity with your brand and customer loyalty. It's therefore important to ensure you can stop others using the same or a similar trademark in a way that could confuse customers, divert business, or damage your brand's image. For instance, if there are lots of other businesses using the same or similar trademarks as you in the same or similar fields, it might be difficult for customers to reliably recognise and remember you, and to develop a relationship specifically with your brand. Even if there's just one other business using the same or a similar trademark in the same or a similar field, customers could confuse the two of you, and custom could be diverted to competing business. Moreover, if such other businesses offer goods or services that are defective or of an inferior quality, and customers mistakenly think that the goods or services originated from you, it could be the reputation of your brand that takes the hit. Registered trademark protection helps you to prevent or deal with these types of issues by giving you rights that you can enforce against third parties.
As a practical point, registration is also important because in general, UK trademark rights are given on what's known as a first to file basis. So this effectively means that the party who successfully applies to register the trademark first will have the upper hand. So by avoiding or delaying securing trademark protection, your business could encounter problems further down the line if another party registers your trademark or a similar sign in your commercial field. One caveat to that is that UK law does provide some protection for unregistered trademarks that have been used by business for a number of years. But registered protection is still more comprehensive because it offers nationwide exclusivity, whereas use-based rights can often be limited to a specific geographical area. Thirdly, if you need to enforce your rights against a third party, it's much more straightforward if you have a trademark registration to rely on to prove that the right exists, rather than having to prepare a lot of evidence to show that your business has rights to an unregistered trademark. It is also worth noting at this point that owning a registered company name with Companies House or holding a domain name does not mean that you own that trademark from a trademark law perspective. So company names and domain names are a related area, but they are distinct, and it falls outside of the scope of today's talk. However, please do get in touch with us directly if you want to discuss these issues further.
Aside from being useful in terms of protecting your business, trademark rights are also assets that can add value to your business. They can be sold to other parties, leveraged as security in business deals or for loan or investments, and licensed or franchised to other parties in exchange for royalties. By registering your trademarks, you essentially ring-fence your intangible assets and enable yourself to commercially exploit them. Additionally, if you're a smaller company or a startup that potentially hopes to be acquired by a larger company down the line, or you even just want to gain investment, having proper trademark protection in place can make you a lot more attractive to potential buyers or investors. Now, this is because a lot of the value of your brand and business is tied up with your trademarks, including your goodwill and recognition among the public, and the selling power of your brand. A company looking to acquire or invest in you is going to want to know that you'll be free to continue using your trademarks and that you can protect your brand against other companies. If you haven't protected your trademarks and checked that you're free to use them, you could look like a riskier investment. This is because there would be a risk that another business might obtain rights in a relevant mark before you, or might already have done so, in which case you might ultimately be forced to rebrand and have to put in a lot of effort and expense gaining goodwill and reputation in your new trademark. In summary, registered trademark protection can help you protect your business interests and the valuable goodwill built up in your brand over time, as well as add value to your business.
So in terms of what owning a registered trademark enables you to do, in the UK, you would be entitled to stop or prevent others from using in the course of trade or registering the same or a similar mark in respect of the same or similar goods or services if consumers are likely to confuse those two trademarks. So this definition is quite wordy, but if we sort of break it down, it basically means that if somebody tries to sell goods in the UK under a sign that is similar to yours, or if they apply for a trademark in respect of those goods, then even if that sign and those goods are not exactly the same as your trademark registration, you would have grounds on which to prevent them from doing so if customers might be confused. So to put this into context, in recent UK opposition proceedings, the owner of the earlier trademark Bonvoy was able to successfully oppose an application for the mark Bankboy for overlapping banking services. So even though these two signs have visual and phonetic differences, in particular the way they're pronounced at the beginning of both of those marks is quite different, the common first letter and the endings were enough for these signs to be found confusingly similar. So really, the point I want to make here is that the scope of protection you get with a registered trademark is broader than the mark that you use, because it covers not only identical, but also similar marks and goods and services. It is also worth noting that if your trademark is particularly well known, then you can actually stop others from using or registering a similar mark in a completely different commercial field by arguing that such use would take unfair advantage of or tarnish your trademark's reputation. There are quite a lot of nuances to that point, which we aren't going to go into detail in this session, but please get in touch if this might apply to you. So hopefully that's provided some guidance about why trademark protection is important. And so now we're going to turn to the more practical considerations relating to the trademark registration process.
So when should you register your trademarks? It's generally advisable to seek trademark registration as early as possible. This is so you can try to avoid someone obtaining rights in a relevant mark before you, be it intentionally or even just by chance. Trademark conflicts don't only happen when someone intentionally tries to rip off another business's brand. A lot of trademark conflicts arise when companies just happen to have chosen similar trademarks. By filing trademark applications as soon as possible, you reduce the risk of someone else getting in there before you. However, and this is slightly big however, before going ahead with registering a trademark, it's important to have some searches conducted to check for any existing trademark rights that could block you from registering your mark, and more importantly, that you might risk infringing by using your mark. If you won't be able to use your mark because another business could sue you for trademark infringement, registering the mark would probably be a waste of money. Searches should ideally be conducted in all of your countries of interests, and searches typically focus on the trademark registers and look for identical or similar trademarks covering the same or similar goods and services. The costs depend on the number of countries involved and how thorough the searches are. For example, narrower initial searches, just for the identical mark or very closely similar marks, can be cheaper than broader searches that aim to be as comprehensive as possible. The costs also depend on how many classes of goods and services need to be checked, and Alex will explain a little bit about classes later on in this webinar. While searches incur costs at the outset, they do help to reduce the risk of running into difficulties and more substantial costs later down the line. If you find out further down the line that you're infringing someone else's trademark rights, this could cause you substantially more inconvenience and expense. For instance, if you're sued for trademark infringement and have to pay damages to the trademark owner, and if you're forced to rebrand, it can be very costly to go through a rebranding process, change your packaging and your materials, educate consumers of your new mark, and ultimately regain goodwill and recognition under your new mark. So in summary, you should ideally only consider using and seeking to register a trademark once you've had some searches conducted.
So once you have established that you're safe to use your trademark following searching, deciding what to protect seems straightforward. You want to protect the trademark that you use. But in reality, it can be a bit more complicated because businesses often have a number of signs that would be suitable for trademark protection. And these can often appear in a variety of colours, fonts and styles, depending on where they're found. So whether that's on websites, business cards, invoices, and so on. Obviously, it can be quite impractical to register each and every iteration of your trademark, and often it's not necessary to do so. And so you need to consider which signs and which versions of those signs should be the subject of register protection. Often, a plain word mark can be used to register a brand name, which then provides you with protection regardless of the colours or fonts used in practice. It's also important to note that it's not possible to change or amend a trademark once it's been filed. And so these are things that do need to be thought about at an early stage. As trademark attorneys, Adam and I would be able to help guide you with this. Certain considerations that we generally take into account are things such as budgetary constraints. So with each additional trademark application, the costs will increase. And so it may be necessary to adopt a more focused filing approach. So a trademark attorney would be able to advise you on possible workarounds to accommodate your budget. And this might be things like registering what's known as a combination mark, which contains both your name and logo. Although this strategy does need to be balanced against the weaker protection that this would offer compared to registering those two elements separately. Something else to think about is use in practice. And the reason for this is that once a trademark has been registered for 5 years, it's vital that you are trading under that mark in order to maintain the registration's validity. Therefore, you need to think about the possible implications that this might have for any colours, fonts, or stylisation that might be a part of any trademark you apply for. And thirdly, it's worth thinking about the relative importance of that trademark to your overall brand. I mean, this really ties into the previous points, but generally it's going to be more important to protect a permanent brand name rather than perhaps a secondary slogan, which might change over time. So a good question really to think about here is, how will your customers primarily encounter and remember your brand?
Aside from considering the specific mark you want to register and in which format, it's important to consider whether the mark is actually likely to attain registration. One of the main requirements for a mark to be registered is that it's capable of distinguishing your goods or services from those of other businesses. In other words, the mark needs to be something consumers could rely on to identify you. This will not be the case if, for example, the mark describes the goods or services, or if it consists of fairly common or promotional indications. To give you some examples, the word chocolate is the name of a category of goods and a flavour, so would not be seen as distinctive for chocolate bars or for chocolate flavoured or chocolate scented goods. The word fresh would likely be seen as describing the freshness of food products or perhaps the scent of cleaning products. The word cheap would be seen as describing the price of goods or services, and words such as best are generally laudatory or promotional and would be seen as describing the quality of goods or services and promoting them. Now, the general reasoning behind this requirement is that it would be wrong to allow monopoly trademark rights over these type of indications, because other businesses might need or reasonably want to use such indications in a descriptive or a generic way. For example, if Cadbury were granted a trademark registration for the word chocolate and could stop others using that word in relation to chocolate bars, it would be very unfair on and a major problem for competitors such as Nestle. Now, in contrast, the name Google is a made-up word, so isn't innately descriptive of any goods or services. The name Apple is an existing word in the English language, but has no meaning in relation to computers or phones. These are therefore examples of trademarks that are inherently distinctive and registrable for the relevant goods. Now, it might be possible to register an inherently descriptive or non-distinctive trademark once you've used it for a number of years, if you can prove that consumers have come over time to perceive the sign as identifying the goods or services of your business specifically. However, this requires a number of years of use and a lot of compelling evidence, and it makes the application process a lot more time-consuming and costly. While there may be marketing appeal in having a trademark that indicates what the goods or services are or promotes their qualities, from a trademark perspective, it's advisable to use signs which are further removed. This is not only so that you can protect your brand against other businesses. From a commercial perspective, it can be beneficial to have trademarks that are more memorable for consumers and stand out from other signs being used on the market, so that you can more easily build up awareness of your brand and valuable goodwill among the public. Further, if you choose to use a descriptive or non-distinctive mark, which you probably won't be able to register, you won't then be able to stop others using the same or similar marks. So in summary, there's a lot to think about when selecting your trademarks and working out what precisely you should seek to register, and a trademark attorney can assist with this.
As well as thinking about the sign that you want to protect, you also need to consider what products or services should be covered by the trademark application. This is because trademarks don't offer unlimited protection. Their scope is defined by a specification, and a specification is basically a list of goods or services. So the starting point is to protect your trademark for all of the goods or services that you either use or intend to use your trademark for. This is because you cannot add further goods or services once the application's been filed. And so as a result, you may want to think about trying to future-proof your protection by extending the coverage of the application to include additional goods or services that you see your business potentially expanding into in the future. As a practical point, you need to be aware that all of these products and services are categorized into 45 different classes. So for example, electronics typically fall within class 9, vehicles in class 12, clothing in class 25, and so on. A trademark attorney will be able to prepare a list of goods and services classified accordingly for your approval prior to filing. It's important to note that the application filing costs do increase with the number of classes covered by an application. And so this might determine the strategy when you are filing your trademarks. It might be necessary in particular for businesses whose goods and services fall across a number of classes to be more selective regarding the scope of an application in order to keep to a certain budget. So for example, a clothing brand might offer goods such as sunglasses, jewelry, and bags alongside the clothes, but all of these goods fall within different classes. And so in those circumstances, it might be necessary to focus on the particular products that are the core of the business. A trademark attorney would be able to assist you in obtaining cost-effective coverage within any budgetary constraints. So really the main takeaway point here is that it's important to spend time deciding exactly what trademarks you want to protect and for what goods and services before filing any applications. This will ensure that your trademark portfolio can be as streamlined and therefore as efficient as possible for your business.
Now we've discussed what to register in terms of the marks and goods or services, we need to talk about where you should seek to register your trademarks. Trademarks are protected on a country-by-country basis, and the law, practice, and procedures vary from country to country. There isn't such a thing as a single worldwide trademark registration, and a trademark registration in a particular country generally only protects your mark in that specific country. You therefore need to work out which countries you wish to seek trademark registration in. Now, ideally, you would seek registration in all of the countries in which you foresee using your trademark. It's also worth considering protection in countries where your branded goods are manufactured or imported through, especially if this is in a country such as China, where a lot of businesses encounter infringements and run into trademark difficulties, such as people knowingly registering the well-known trademarks of overseas companies and effectively squatting on the register. While the general position is that separate applications are required in each country, there are some exceptions and ways of streamlining the process. For example, it's possible to register a trademark covering the whole of the EU by filing just one European Union trademark application with the European Union Intellectual Property Office. There is also an international system for filing one application with the World Intellectual Property Office, designating multiple countries of interest to you. This is ultimately examined by each country individually and forms a bundle of trademark rights in multiple countries. It's also possible to stagger your trademark applications by filing just one application initially and then applications in further countries up to 6 months later, claiming what's called priority from the first application. Claiming priority means that your later applications share the same earlier filing date as your first application. This can be important in terms of trying to ensure your application is earlier than those of other businesses. It also helps you to spread the cost of filing trademark applications and helps you buy some time to consider your strategy for seeking protection in additional countries. A trademark attorney can help you to devise a filing strategy for obtaining appropriate protection for your trademarks in a cost-effective manner and talk you through all of your options.
So we've covered the various key issues and considerations to be taken into account when thinking about securing trademark protection. And now we're just going to briefly outline the application procedure. This differs by each country, and so we're just going to focus on the UK today. So the first step is to file an application form with the relevant trademark office. In the UK, this is the United Kingdom Intellectual Property Office, or UK IPO. Filing a UK trademark application through Dehns for one mark in one class costs £550. That includes the official fee, but there would be additional charges if extra classes were added. As part of that process, we would advise you on some of the issues that we've previously outlined in this webinar, such as the format in which you should seek to register your trademark and the filing strategy, as well as preparing the list of goods and services. Once the application has been filed, the UK IPO will examine whether the application meets the formal and legal requirements for registration. And so this includes issues like the accuracy of the classification and ensuring that the trademark is not descriptive. If the application is not acceptable, the UK IPO will raise an objection and will provide an opportunity for the applicant, usually via a legal representative, to take steps to try to overcome that objection. So this might be by amending the list of goods and services or by submitting arguments and evidence to try to change the UK IPO's mind.
Now, once any such objections have been overcome, your application will be published for 2 months, and other people or businesses would have the opportunity to object to your application, usually on the basis of earlier trademark rights, by filing what were called oppositions. Potential opponents can also extend the deadline by 1 month. If an opposition is filed, you and the opposing party enter into formal proceedings before the Trademark Office, which involves both parties submitting arguments and evidence, and potentially a hearing. Alternatively, you might be able to reach an amicable settlement with the opposing party. It would be fair to say that the majority of trademark conflicts are settled between the parties. One way of resolving an opposition could be coming to an agreement that allows both businesses to use their marks in a way that would avoid or minimize commercial conflict. For instance, they might agree to use their marks in different stylized ways, or make them appear more distinguishable in practice. Or they might agree to use their respective marks in relation to delineated subcategories of goods or services, or different business sectors. For example, if both parties are in the software market, one party could agree to only use its mark for banking software, and the other could agree to only use its mark for photo editing software. Settlement agreements like this are not uncommon, but come with a number of risks. It's always highly advisable to work with a trademark attorney when entering into these kind of arrangements. For example, you could otherwise find later down the line that you've unintentionally tied your hands in a way which isn't commercially viable to you. If no opposition is filed, or any opposition is successfully defended or settled, the Trademark Office will register the trademark and issue a certificate of registration. For a straightforward trademark application in the UK that doesn't encounter any objections, oppositions, or other issues, you could obtain registration within 4 months from filing your application. However, it could take a lot longer if objections are raised or oppositions filed. Registered trademarks are protected for 10 years in most countries, including the UK, and can be renewed indefinitely. In this way, trademarks differ from other forms of IP, such as patents, designs, and copyright, which are only valid for a certain limited time period. As long as you keep renewing your trademark registration and another person or business doesn't manage to cancel the registration, you can keep it forever. However, as Alex briefly touched on earlier, continued use of the trademark is vital in order to protect your registration from cancellation on grounds of non-use, and to ensure that you can actually enforce your registration against other businesses. For example, if you have registered your mark in a particular stylized manner, and over time you come to use your mark in a different stylized way, you could find that another business could successfully attack your registration and have it cancelled. Additionally, after 5 years, to rely on a registration against an infringer or in an opposition, it's likely you'll be required to provide evidence that you've used the mark as registered for the goods or services covered by your registration. Therefore, if there are changes to your branding or the goods and services you offer, you should always consult with your trademark attorney to see if any new trademark applications are required. You also need to keep the trademark register up to date with changes in your name and address, any changes of ownership, and any transactions affecting the trademark, such as licenses. A trademark attorney can assist with recording changes in your details and in effecting and recording transactions, such as changes of ownership and licenses.
So this has been a fairly whistle-stop tour of the function, importance, and practicalities of trademarks in the UK. But we hope that this has provided some insight as to the types of things that business owners should be thinking about, both prior to launching and throughout the duration of the business. Our key message really is that it is never too soon to be considering trademark protection. The earlier you carry out searches to see if you are able to use and register your trademark, and the sooner you are able to file an application, the more likely it is that you will be able to register your trademark and enjoy the protection that comes with it.
And once registered, continued maintenance of a trademark portfolio is vital. You should be sure to use the signs as registered, renew your trademark, review how your trademarks are used over time and develop over time, and seek to address any gaps in protection as soon as possible, including for any new marks you adopt or for new goods and services you launch. Now, thank you very much for watching. We hope this has been informative and helpful. But if you do have any questions or require any assistance with your trademark matters, please do get in touch with us. Our details are on screen now.